The certified true copy of the Court of Appeal judgment of November 18 on the governorship election has generated heightened concerns amongst parties to the legal battle. While the new Nigeria People's Party NNPP, which obtained the copies after its candidate and governor of the state, Abba Kabir, was sacked by the appellate court, insisted that concluding part of the judgment, as shown in the CTC, was actually in its favor, contrary to the oral one delivered by the panel. On the other hand, Chief Registrar of the Court of Appeal was speaking on the contradiction after owning up to the release certified true copy of the judgment issued to the NNPP, dismissed the passive blunder as mere clerical error, which can be corrected by virtue of the slip rule. Now, meanwhile, all Progressives Congress APC, in what looked like a counter press conference by the NNPP, highlighting the judicial misnomer, first said, though it was yet to get at the time the CTC of the Friday 18 appeal seeming contradiction as captured in the copy before the NNPP, it must have been an error which ordinarily should have been overlooked. On Daily Politics tonight, we ask, what constitutes slip rule as it relates with the judgment, whose CTC suggests it affirmed the NNPP victory in Kano, set aside tribunal judgment and awarded 1 million naira to its governor, Abba Kabir. Now, what is the scope, the framework, the applicability and implications of this slip rule on the dispute, the disputed CTC of the Court of Appeal? And we have in the studio constitutional lawyer and a senior advocate of Nigeria, Barrister Sam Kagbo. Thank you for joining us.
Thank you for having me.
Right, before we commence the conversation, let's take a look at the recent development, the most recent one now, talking about the judgment of the Court of Appeal on the election appeal of the Kano State, of Nasarawa State, which was brought to aid by the incumbent governor, Abdullahi Sule of the All Progressives Congress, the APC. Now, Abdullahi's approached the Court of Appeal, after his election was invalidated by the lower court in that state. Now, the Court of Appeal has restored his mandate and, and also invalidates, if you like, or set aside the judgment of the lower tribunal. So let's take a look at this report, and then when we return, we continue with the conversation. The appellate court in its judgment on Thursday set aside the lower court ruling, stressing that the appellant was denied fair hearing. In a unanimous judgment, the three-member panel led by Justice Uchechukwu Onyemenam reversed the nullification of the election of Governor Sule of the APC. The appellate court's decision is on the grounds that the tribunal wrongly relied on the evidence of 8 of the witnesses that were produced by the PDP candidate, whose statements and oath were not front-loaded alongside the petition. It also held that Section 205, subsection 5 of the 1999 Constitution as amended, Section 132, subsection 7 of the Electoral Act 2022, and paragraphs 4, subsection 5 and 6, and 14, subsection 2 of the first schedule to the Electoral Act posits that every written statement on oath must be filed alongside the petition within the statutorily allocated time. The panel of justices held that the evidence of 12 remaining witnesses that testified for the PDP candidate were not sufficient to sustain the judgment of the tribunal after it struck out all the evidence and exhibits that were tendered before the tribunal by the 8 witnesses. The appellate court in another breath held that the tribunal acted in error when it deducted a total of 1,868 votes that were credited to Governor Sule on the premise that overvoting occurred in 4 polling units, even when the petitioners failed to provide necessary documents needed to prove overvoting. Dismissing the split judgment of the tribunal delivered on October 2nd, the court also vacated the order of the tribunal directing the Independent National Electoral Commission, INEC, to withdraw the certificate of return issued to Governor Sule, as it affirmed him as the winner of the governorship contest. In March 2023, the Independent National Electoral Commission, INEC, declared Abdullahi Sule winner of the Nasarawa State governorship election with 347,209 votes against David Umbogadu of the PDP, who scored 283,016 votes.
Thank God for the judgments just delivered. They were well considered. Out of all the judgments that were delivered, I think today we say it was 4-0.
It was rather a very strange misconception of the case. And happily, this is not the final court in this matter. We already have instructions to test the decisions that have been rendered this afternoon, and we have already swung into action.
We've gone into a game, and in a game, there'll be a winner and there'll be a loser. And of course, you don't expect the losers to celebrate. And they understand the way they feel, and but the most understand, we must first of all have a state.
Thank you very much for staying with us. And that has been the outcome of the proceedings at the Court of Appeal today, with particular reference to the appeal in respect of the Nasarawa State governorship election, which was settled, if you like, by the Court of Appeal, even though we've had it there that the respondent is approaching the Supreme Court to also seek redress. Back in the studio, we still have Barrister Sam Kago. You've been following very, very closely the development in Nasarawa State, especially in respect to the lower court reasoning, if you like, and the issues for determination at the Court of Appeal. Today, it has been finally laid to rest here, you know, at the Court of Appeal. What do you make up with the submission, if you like, or the conclusion?
If you're talking about the opinions of the Court of Appeal, the
That's
issues have already been settled, you know. From the moment we had the judgment on the presidential petition, all lawyers now know the trajectory and the authorities on the issues regarding witnesses and witness statements that you bring after the expiration of the 21 days. The Supreme Court has said no, that's a no area, because the Constitution is sacrosanct, and the Constitution always means what it says. 21 days, and you can't bring your petition piecemeal, because what constitutes a petition is your allegations, your witness statements, and your documents. That's what constitutes the petition. So you cannot bring your petition piecemeal. And there is the argument that, oh, that in itself goes against the grain of justice. But here is the catch. If you allow people to bring their case piecemeal, there is that tendency that somebody who is running out of time can just put in minimal evidence in support of his case and go shopping and go to town to look for evidence. Because in any case, what we're talking about here, we're talking about what happened on election day. And before you decide to go to court to challenge their election,
you must have gathered
there is that
evidence.
Every logic that you already have the evidence in support of your case. It has to be the same like the case of a blind man who would say, I will stone you. Before he says that, he must have been standing on top of the stone. You understand? So this is the thing. I don't have sympathy for anybody who, after the 21 days, that's the time you now start bringing in witnesses, you start bringing in documents, because what that one would do, it will violate the issue of expeditious trial. You understand?
Yeah.
Because you have only 60 days, what do you call it now, 180 days. And when you bring your own witness, you bring your own evidence, of course the other party has the right to rebut. That right of rebuttal will also mean that he will also bring his own witness, he will also bring his own evidence. So that will be what? No end to
the litigation.
Not the litigation, the presentation of facts. You understand? So to me, that in itself is sensible, logical, and that's what I think the Constitution means, because the Constitution tried to move away from the old regime. The old regime was such that you could have a case for 3 years.
Yeah, it's open.
It's open-ended.
That's right.
And for 3 years, you are litigating. And when somebody loses now, somebody has what? Enjoyed 3 years of illegal, if I'm to use the benefit of the office, and the spoils of office as well. And you cannot ask him to regurgitate it, to say, okay, bring back what you have back, because what?
So in other words, it helps keeps the time frame.
The time frame, that time frame. That time frame. And let me tell you something. When I was part of the government white paper on the electoral reforms. There are some lawyers, non-lawyers, the NGO people who were looking at other jurisdiction. They say, oh, let's leave it for 3 months. Some of them were even saying within 1 month. And I said, no, we are operating an adversarial system that does not allow the judge to be a finder of facts. Those who are operating the continental system, most of the French countries, the judge is both the finder of facts and applier of the law. So they can look at the documents and make their own conclusions and opinions. And if there is a doubt, they would only ask the lawyer or a non-lawyer. In some places, they have agents. That is, if you have your case and you are not a good pleader, you are allowed to what? Employ an agent who is a better talker to come and plead for you. Then the lawyers will just come and argue or make what they call the legal pleas.
That's right.
You understand? So the judge has absolute control over the proceedings and the entire trial. But here,
and
no.
In this case, yes.
Here, the judge is supposed to be a referee.
The onus is on the
on the parties. You understand? So I think those are foregone conclusions, and I do not see any departure from that.
What do you make about the reasoning along the line of the issue of overvoting? Because the appellate court is saying that the evidence provided, were not substantiated, in respect to overvoting. The petitioner, if you like, did not substantially establish the issue of overvoting, and that's the reason why the appellate court said, it shouldn't have been, the basis for the. Some of our colleagues have a misconception of the provision of Section 137 of the Electoral Act that says that if you have a document that on its face establishes conclusively an issue of a malpractice, you don't need to bring in oral evidence. But that in itself flies against the grain, because the law is already fixed. When I say fixed, immovable as to what you need to prove the allegation of overvoting. You have to bring the register, and the register you are bringing, somebody has to speak to it as a witness. You have to bring the results. You have to bring what? The beavers report and the beavers itself. All of these things must be there because it has to be conclusive. You understand? Because there is already a presumption of regularity in the result, and you are the one challenging it. So you do not expect the judge to make inferences from mere document he presented before it, because that document could be doctored.
You understand? And it cannot speak for itself.
That's right.
So the law says this is what you need to establish. You bring in what? The register, because what does the register do? It would show the number of tickets for everybody that votes. That is a tick.
Yeah.
So that number in itself, it's there to establish that point. And of course, the beavers has the last word on those who were accredited and those who voted. So if you don't bring this and you only rely on documents, then obviously you have not reached the threshold for the establishment of that allegation.
That's right. Okay, let's move to our topic, the talking point today. We're looking at slip rule. Okay. For to many Nigerians, they're hearing it for the first time.
Yeah?
They don't know that something like that exists. So we need to know, because it has become, an issue on the front burner. Now, everyone is looking at it. The parties to the Kano governorship tussle are now, putting their arguments around this. Let's understand what it means first. What is slip rule?
But let me start from the conclusion.
Okay.
Let the parties concentrate on the ball.
Okay.
Time is running.
Okay.
Do your appeal. Concentrate on that. These are all.
I think they are beginning to understand.
Yeah, no, this is not just. It's even if there was a word to say, what did they call it now? You want to make a mountain out of what do you call it? Yeah, those are those things. You see, what does the slip rule is? Let me reduce it to what I think the public will want to hear. There is always that possibility of errors in the judgment, which are critical. I mind you, sometimes the judgments are rendered in longhand. You understand?
Okay.
Because they have time within which to deliver the judgment.
Okay.
They have time, so they are always under pressure. Even for regular cases, except you have a very expansive or cogent reason, you must deliver your judgment within 90 days.
That's right.
So in the process of typing, there could be those clerical errors. And sometimes you see them even when they are delivering their judgment, they are making corrections.
That's right.
So when you send it back to the clerks to do, there could be those clerical errors. Those errors do not touch the substance of the case. For an example, if you are talking of a date of today's 23 November 2023, and the other person now writes 23 December 2023. That's a clerical error. That's a clerical error.
Yeah. Yes. Okay. The reason why I want us to put the issues in context, because just like you said, we needed to know first of all what it means, and then two, what constitutes that slip? Because
that's what I'm saying. Clerical errors. It's an error that you know on the face of it. Mere seeing it, you know that this is an error.
Is it open-ended? Because the contention here is that I understand the example you're trying to give, just like many others have been given. I've had Timmy Frank also, not Timmy Frank now, Odinkalu, talking about, for instance, you want to write wife, and then you say Wi-Fi. So this is a clerical error.
Very much.
I understand. And then perhaps it also revolves around issues like maybe prepositions, articles, and so on and so forth. But in this case, people are talking about 3 major paragraphs in a judgment and concluding part of a judgment.
No, but you see, let me just take one part of the paragraph.
Okay.
You say this appeal lacks merit. Who has appealed? Is it the appellant?
That's right.
So if you are not saying so, the issue is resolved against the what?
The appellant?
No, the respondent.
The respondent,
and in favor of the appellant.
Yes.
It doesn't make sense. Somebody will say, "Oh no, there is an error there because what you meant is like you changed the names of the parties instead of saying
the issues are resolved against
against the
appellant.
The appellant.
Against the respondent.
Because you've dismissed the petition, the appeal. Once you've dismissed the appeal, it means all the issues are against the appellant. Are in any way. What you have in the final analysis is a summary of your findings and holdings you've had on the way.
Yeah.
For each issue presented, you have analyzed it, you have evaluated the evidence and made a finding and made a legal conclusion.
Yeah, but the conclusion,
you understand?
Here, I think
so for all of that, it comes a long way. So if from A, B, C to Y is all against the appellant, then Z, you now change the language, somebody will tell you, no, something is wrong.
But isn't it a possibility? Because I've seen reasons, you know, some will...
No, listen, we are talking tentatively here.
Okay, because I've seen judgments where in the first place, if you're following the trend, you think, you know, the petitioner, for instance, if it is a petition, is going to win the case. But towards ending, you begin to see also some sort of reversal in terms of...
those are preliminary issues. Those are issues that do not touch on the substance. The issues that will touch on the substance, those are issues are caught and presented before the court. Once you finish your own analysis and evidence evaluation, given them their own probative value or discarding some of them, you make your decision on that issue. That is one.
Okay.
You go to the next one, that is two.
Yeah.
You understand? Yeah. So on the whole, and summary of that is that what? The petition lacks merit.
Yeah, it's hereby dismissed.
And it's hereby dismissed.
Yeah. Or
to go further, in fact, is a surplusage because you've already done the job. You understand?
Yeah. But in this case, you know, you talked about the aspect of, you know, finding appeal not based on merit. You know, it's lacking merit and so on, and hereby it is dismissed. Yeah. But one fundamental aspect of it that generated a lot of controversy has to do with where the Court of Appeal, you know, in the CTC did mention that it has set aside, you know, the judgment of the lower court. So to set aside the judgment of the lower court for the appellant means restoring his mandate, for instance. Definitely. So that is contentious.
Yeah, that's a contentious one. Definitely. But where is that one? If it's a standalone statement, the earlier reasoning of the court does not correlate with this, you will know that there is an error. But even as that, even if it is not an error, on appeal, mind you, the respondent in that way is going to appeal against that very particular decision because what? It runs against the grain of the reasoning of the court. Yes, sir. You understand?
Just like they did.
Yeah, they would have to.
Right now they're exploring that ground.
No, they have to. They have to because what? You see, they have to because the Supreme Court would have to set it aside to say, oh, because of this, they will give the particulars. That would what? This justify the conclusion. The ground for it to be set aside. You understand? Definitely, you would say, oh, the Court of Appeal erred, you know, and arrive at a very perverse conclusion when it held that blah, blah, blah. Then you will now state the facts. The facts will now mean, hey, you made all of these findings, all of these holdings in my favor.
Put them straight now.
Straight now. Then you will now make. That's going to be a walk in the park. You understand? When I say, but coming back to the issue, I saw...
There's still one other ground.
Yeah, I saw...
I mean, one other area of contention.
Yes.
Even though that looks for both sides or against both sides, so to speak. Yeah. You know, in one breath, the Court of Appeal is awarding 1 million naira, you know, to the appellant. On another hand, I think in one other breath, it's also talking about, that is in the oral judgment, it's talking about awarding ₦1 million against the appellant. But in the CTC...
The judgment read in the open court is the judgment.
Okay.
You cannot change it.
Okay.
What you've read, that is why you are bound to deliver your judgment in open court. It can be through via Zoom or via whatever, virtually or whatever it is. But that is the judgment. So if there is a discrepancy between your oral judgment that you render in open court and the written one, then there's tampering.
But in this case, is it not what is obtainable?
No, listen, but you see, I don't want to go to that point because that is too fundamental for you to go to that extent. I want to restrict myself because I know that these gentlemen are working under the furnace. These gentlemen are overworked, and usually the clerks, registrars who do the typing, they cut and paste conclusions.
Okay.
You understand? Most times we suffer it too. Maybe when you are making a notice of appeal, tell them, oh, that is this appeal we had the other, copy from that introduction. Because you as a lawyer would not want to go and sit down and start to do those administrative, those usual mundane things. So, and they will mess it up. You know, somebody, a judge had told me in open court that, oh, the business of the law is not for carpenters. And why was it? I put 2011 instead of 2012 as a date on the notice of appeal. Something that is innocuous. But he made a statement against me. Unfairly. You understand?
And it has to do with the negligence on the part of...
no, it is my negligence.
Okay.
But these things happen. You understand? These things happen. So if you are a lawyer, in any case, every lawyer, except if you are not in practice, if you are in practice, you will even, those are things you discontinue entirely because you know they happen.
Just like...
You understand? And there is that opportunity for them to be corrected. So why the fuse?
We'll talk about the correction, which is also controversial.
What is the controversy there?
It is also generating its own kind of reaction. Now, I mean, the Court of Appeal is asking the parties to return the CTC, I mean, the controversial CTC, you know, for the corrected one.
No, they can't. You see, the 60 days they have has been run down. Okay. You know, they deliver a judgment, I think, on the 59th date. Okay. They cannot.
They cannot retrieve them?
No. That matter has gone beyond them. It's now for the Supreme Court. You see, take a look at it. And these are also the issues of when you give credence to social pressure or public pressure. You understand? Maybe that's why they are reacting like that, asking for it to be returned to you when you are functus officio. You are close. It is not like the ordinary open-ended matter. If this the ordinary open-ended matter, I can come back to you, of course, make the application, formal application. It is not something you
just do on your own.
No. It is not something that you instigate. It is not you. You are not affected. It is the affected party that will have to make the necessary application, and you determine the merit of it and do the necessary adjustment. But not for you, because you
just do it.
You want to react to public listing. The public is not abreast and not really in the picture of the condition that these gentlemen are working under. Believe me, election petitions are killing these people.
Especially now that you have a time frame.
The election petitions are infernal. You understand? Some of them, how many of them they had to juggle from the courts? Look at them now. The whole of them are now tucked into Lagos to do the Southern cases.
Right.
Then the other for the north, they are all in Abuja here. They now have to borrow courts. They now have to, under all sort of funny environment. You do that, and some of them, because there are 33 in the panel,
yes,
you see them hearing up to 10 appeals.
That's right.
And those appeals are most of the time...
Some would even cross appeals, you know, and so on.
Yeah, most of the time, those adoptions are done perhaps a few days to the end of time.
That's right. That's right.
A few days to the end of time, and time is running, and they have to. And that would now mean that if you are on a panel, maybe you have 10 cases or 12 cases, you have to share it 444, and you have to write those judgments within days. I would always tell our colleagues, do back-to-back addresses or back-to-back briefs. When you do that, you now know what these gentlemen are going through.
That's right. Okay, we'll take a break, and when we return, we'll be looking at what need to be done perhaps to ease this burden, or perhaps to make this seamless, so that the justices would not be stressed this much, that to the extent that they would deliver, or they would be seen to be delivering a contradictory judgment. In case you're just joining us, the program is Daily Politics, and we're dissecting the slip rule, as it relates to the Court of Appeal judgment, especially in respect of the Kano governorship tussle, which generated a lot of controversies. And I have in the studio a constitutional lawyer and a senior advocate of Nigeria, Barrister Sam Kagbo. Together, we've been looking at the issues very closely. We will take a break. When we return, we'll continue with the discussion. Stay with us.
We started manufacturing leather since 1958. But the most important thing is that if the system is checked correctly, we won't have where we are now.
If somebody has depression, they may just be very irritable and unproductive in the office. So you find on average already about 1 in 4, 1 in 5 Nigerians already have mental illness, a mental health condition that needs some form of attention.
No matter how good an economy is, if the federal government goes bust, believe me, everything in the economy is just a matter of time it will go bust. So first of all, about maybe slightly above, below 70% is in federal government securities.
If government has banned importation of fertilizer and states are doing it at the level of governance, but I believe that production and distribution of fertilizer should be left to the private sector.
This is the general multi-purpose card, and it has a chip here. So this chip is about 80 kilobytes. The one that you get from the bank for ATM is just 4 kilobytes. So this is like 20 times.
Thank you very much for staying with us on Daily Politics. And today we're looking at the slip rule, and the legal system, Nigeria's legal system, especially as it relates with controversial, position around CTC, that is Certified True Copies of Judgment obtained from the Court of Appeal in respect to the Kano governorship tussle. And in the studio, we still have Barrister Sam Kagbo, a senior advocate of Nigeria. Before the break, we were looking at whether, the Court of Appeal or the registry of the Court of Appeal has, can recall those controversial CTCs, or whether, and how that will affect the time frame for the appeal. Yeah,
because there are two issues here. You're talking of, let's not mention the registry here. The registry is just errand of the court.
But it's the registrar, the chief
of course, it's acting for on behalf of the judges. PJ there. Yeah. But the issue is, can the court acts suo motu on that issue. I do not think so. Okay. It has to be a very formal application by the affected party for the corrections to be made. Okay. And if
can one party do it, or it has to be by
no, one party can do that. One party can do that.
Okay.
But it can even do it ex parte.
Okay.
Because it's a correction. That's
but the reason why I ask that question is this: you know, one of the parties, that is the All Progressives Congress (APC), as at yesterday, you know, is saying that it is even yet to have access to the CTC, which means anything can happen. You know, since it didn't, the controversial one, or the one in the hands of NNPP, it's only in the hands of NNPP. It hasn't gone to other parties. Perhaps maybe a corrected one will now be issued.
Yeah, but you see, let's talk about the one that is out.
Okay.
You see, because like I said, I do not think that the court can act suo motu, especially for this election petition things. You cannot. And I think the pressure or the reaction has to do with a response to public outcry.
That's right.
But those public outcry in itself are maliciously directed by people who just want to impinge on the integrity of the court. But I would tell you for free that there is no malice from the side of the court. Okay. I believe it's...
So there shouldn't be any cause of alarm.
No. And there shouldn't even have been. You understand? And in any case, when you now say you want to recall the judgment, you've delivered judgment on the 18th. Yeah. Today is what?
23. 5 days later.
5 days gone out of the 14. The 14 days. You understand?
For the,
not the for the appeal
appellant,
after the judgment. The day, like I said, the judgment day is the day.
Start reading from that.
Yeah, the day the judgment was delivered in open court. Yeah. And it's from there the date starts ticking. Yeah. So if you now recall it, you now go and do this. When does the time start? Not that you're recalling it is going to pause the time.
Yeah, it distorts the...
it will not. To me, just allow them go to the Supreme Court, because in any case, you are already...
done.
The door is shut for you because of what? The time limitation. Yeah. The moment the 60 days are gone, you can no longer have anything with that. It is now in the court of the Supreme Court.
And perhaps that's what the Constitution envisaged now, coming up with the sleep rule now, that can be applied at the court.
Because the law generally allows the appellate court to do that correction. Yes. Because as long as it is a slip or an error that does not touch on the fundamentals, you understand? As long as it's not one that in itself skewed the reasoning of the court.
Yeah, but in this case, even though you said, but in this case...
I wouldn't want to go that point. You see, the slant, most of this malicious slant are geared towards mocking
the judiciary.
It's unfair. You understand? Like, I would always say, I don't know. Some of these people engineering this thing, I tell them, I say, it's so good and easy to be a social media lawyer. If you are in practice,
you know the fundamentals.
You see my face, see how tired it is. I have not slept for 2 days. It cost me more than 10 minutes to wear my shoe. I have to look for shoes that are expandable, because what? My legs are swollen. Yes. Because of the work. Because it's a back-to-back thing.
As a legal
practitioner.
Not to talk about
a judge
who has to go with
these people who are under what I call this furnace on a daily basis. If you look at them, most of them, the moment they retire, they are dying. Because what? They burnt out. Instead of you to sympathize with them, knowing that in any case the things are not bad, because they are not the final court. It is something that can be amended or corrected upstairs. Right. You now make it an issue.
Yeah, when you mention this, you know, it reminds me of what happened, because yesterday, actually we were at the conference, the press conference, you know, called by the NNPP as a party. Yeah, it's one of the questions, you know, we ask. Where are the legal practitioners? Where are the legal advisor? Where are the councils, you know, that represented? It appears it's more like a political, I mean, it's left with the politicians.
The politicians, is their warfare. They think that these people, I'm telling you, I have told people, you know, I've said it here over and over, I said, those people, they have the heart of stone because they will die tomorrow if they get sentimental or emotional. They would, because, hey, your survival depends on you sticking by the law. And forget about, there is nothing like, you are not judging the case for the public. Yes, it is in the interest of the public that the parties before you get their justice. But the justice is according to the evidence they presented, according to the law.
Logics
it is not you to come and make a case for them to suit or fit into the frame of public opinion or public expectation. You will die.
Yeah, but this is quite unfortunate, some would say, because some of the sentiments, you know, as you put it, are rubbing on the integrity of the judiciary.
Unfairly. Because I have said it here, electoral law is mathematical. All the cases that I handled this time around, from Kebbi, Sokoto, Delta, 100%. And from the way I tell the client, I said, go and sleep, this is dead on arrival. There was even one that the judges did some abracadabra. I told my client, he came and said, do you believe in me? He said, go and sleep. That judgment will be overturned. He said, I said, go and sleep.
You're just being honest.
Yeah.
But
a gentleman, a labor professor from Enugu came. He showed me the thing. I look at it, I read it, I get back to it. I said, go and sleep. They've overturned
for
this
some
thing.
Other lawyers, they will give you hope.
They've overturned this thing. They say, up to the last minute, I said, why did you come to me if you don't believe me? I said, forget there is
you don't need to waste your time and waste the time of your client.
No. Another friend of mine who came, his was on nomination. They gave him judgment at the tribunal. I said, this will not stand. I could see him shaking because he expected me to
give him some hope.
I said, no. You came first to me to give you legal advice. And my legal advice is not supposed to pander to your expectation or sentiment. This is, I'm making a prediction. I'm not going to be part of the people who are going to, I'm not going to throw this argument because I'm not part of your legal team. I'm not part. So I'm just saying, so that you don't go and waste money and get this thing and whatever. Somebody come and tell you this, I say, somebody else told him other things. And when the judgment came, he called me and said, oh, I now understand why we were saying.
But in all of this, these political parties have legal advisors. Fundamentally, this is their role. Why are they allowing the things to go this way?
They don't choose. You see, politicians don't go for merit. They don't do reality check. That is the problem we have. They give them the power to appoint justices, for an example. They can't just bring all sorts of people that are connected with them. Because they don't have an idea or an evaluation system to know who is a good lawyer or who is not, or who is proficient in this.
The political consideration, take precedence.
The lawyers who are grounded in election petition are there in the books. From the law report, you know them. And the only way you can be that proficient, I don't want to say good, is you must have been there from the beginning to today, because you must be on top of the legal development for whatever change of direction or
practice.
You must adapt. You must be there from the beginning, and that is the benefit some of us had from day one. For an example, I was in charge of almost all elections in Kebbi.
I remember.
For 8 years, for three consecutive election cycles. And I was the person that was what? Advising for the legal team.
Right, so you're grounded with
issues. So when we talk, we're not talking to say that I'm intelligent. I'm not talking to say that, oh, the others they are not intelligent, and you could bear me witness.
I'm not knowledge and experience.
I'm not the best talker. But I talk experientially because whatever I'm saying is something that is in my blood.
That's right.
So I don't need to go read a book. I don't need to do this thing because what?
So that is the reason why these things are happening, and fundamentally they are affecting the integrity of the judiciary and integrity of the judicial system as it is. Okay, now we have some few moments ago looking at some of the amends, the quick amends, what need to be done. You were talking about, the stress the judges have to go through. Is it as a result of limitation in terms of manpower? That is
that's it too. And you see, these people are taking on. I was, and I have also made that point that most of these our retired justices can still do the job.
Okay.
A justice or a judge who retires at 65, and some of them who retire at 70 are still very strong.
Active.
Why don't you bring them in
to fill
into
the
this
gap.
job? Why don't you also create a special court system that will address election petitions? You understand? Like other people are having what they call constitutional courts. If you do that,
or labor-related courts,
you see,
that are specific
because
to,
I would always say this: if you save money and you lose value in any aspect of the democratic process or any aspect of the constitutional process, the result will be Boko Haram, the result will be banditry, the result will be armed robbery, the result will be bad roads, the result will be all of these things that are consuming us. Because the generator of all the public values and morals and ethics is what?
Justice.
Our electoral system, because that is where we recruit the managers of what? The governance system at all levels. So why don't we give it our
the
best?
leadership recruitment process has to be sanitized.
Let's put money into it to ensure that the court system in itself is insulated from corruption and is empowered enough to do the job timeously. But you cannot have a go and pick them from their regular courts. And as they are picking them from the regular courts, it is not that the sun is standing still and waiting for them to return. No. There are cases they are also piling because they are coming and they would have to what? By the time they go back,
you have to face that again. Well, I hope the leadership, if you like, has listened to all of this and the need, to address them before. I mean, we are looking at the implication already. Deficits around the judicial system or the judiciary as an institution.
Let's empower the judiciary. Let's empower them. Recruit more people. Hey, let's recruit more people into these things. Establish specialized courts so that let people have their day in court. You understand? Timeously, in every respect, I don't feel convinced that what? We should only stop at giving a time limit to electoral cases. No. Criminal cases are pending there. Fundamental human rights.
A number of people are, a number of awaiting trials.
Let me tell you
something.
I taught international economic law at the postgraduate level for 7 years. Yeah. I can tell you that one of the most effective tools for you to attract foreign investment is your court system. How you resolve business disputes. Why is every businessman preferring arbitration? Why is it that even when they employ our own arbitration law, the venue would always be in their own domains?
They're not. There's no confidence in our arbitration system. That's what.
Tell the world that today, no matter what the case is, you would finish your business dispute or commercial dispute within 6 months. The whole world will be here.
Timelessly. Okay, thank you very much, Barrister Sam Kambo, for your informed perspectives on these issues, especially looking at the sleep rule and its application and issues around, some of this contention around, certified true copies and how they are applied. Thank you very much for talking to us on Daily Politics.
Thank you for having me, and it's always a pleasure coming here.
And viewers, that is a wrap on today's package. We sincerely hope you found the conversation engaging and informative. And be sure to join us on Daily Politics on Fridays, where we also open the lines for you to make comments or to air your views on some of the critical topics of discussion. It's interactive, so be ready to join us tomorrow, where we'll be back with another interesting episode of Daily Politics. Until then, on behalf of the technical crew, I am Shafiu Suleiman, thanking you for staying with us.